Filing a trademark application might seem straightforward, but many applications run into problems, not because fees aren't paid, although that is an issue, but because certain important issues aren't considered at the time of filing.
Oh no!
In this video, I'm going to walk through some of the common mistakes that businesses make when completing and filing trademark applications and how to avoid these mistakes. And since I was a former trademark examining attorney at the United States Patent and Trademark Office, I can give you some inside tips to help you navigate this process a bit better.
My name is Elizabeth Seltzer, and I'm an intellectual property attorney with over 30 years of experience assisting businesses of all sizes in navigating trademark and copyright issues. On this channel, I break down complex legal issues into practical guidance that you can actually use to assist your business.
This channel is for general educational and informational purposes only and does not constitute legal advice. Viewing this content does not create an attorney-client relationship, and laws vary by jurisdiction. Is your mark clear for use? Before filing any trademark application, one of the first questions you should ask yourself is anyone else using a similar mark in relation to similar goods or services? This is important because federal registration is only part of the picture in attaining trademark rights, because there may be a third-party user in the marketplace who never filed a trademark application, and they may have superior prior rights to any rights that you may have, even if you seek federal registration. So you want to do a thorough clearance search before you start considering filing a trademark application and using a particular mark. Well, what is a clearance search? A clearance search is not just going to the USPTO database that's available online to the public and searching that. You need to look at other sources, such as looking at state registrations, any type of publicly available database that can tell you about business names, registration, domain name registrations, any type of marketplace use, and other sources that may reveal prior conflicting rights. It's certainly better to identify any of these third-party users before you invest the time, the money, and the manpower into promoting this mark and then seeking federal registration, only to find later on that your application may be challenged.
Is your mark capable of registration?
So another issue to consider is your chosen mark even registerable? And what does that mean? Well, the trademark examining attorneys, when they receive your application, they go through a litany of checklists to consider before allowing your mark to register, because based on certain statutory requirements, that mark may not be permitted to register. And I'll give you a quick rundown of some of those issues that they may look at. I have a list here. One thing they may look at is your chosen mark generic. Is it merely descriptive? Or is it misdescriptive? That's a whole other category. Does it primarily function or serve as a surname? Does it fail to even function as a trademark? A perfect example of that failure to function issue is if a mark serves merely as ornamentation on a good. For example, a decorative design on a t-shirt. That's not functioning as a trademark. It can. There's a nuance there with secondary meaning, but traditionally it is serving as an ornamentation as opposed to functioning as an indicator of source, which is a trademark. The stronger and more distinctive your mark is, the better chance you have at getting registration. Another thing to consider is, does your mark incorporate some type of likeness, name, or image that would reference a living human being? And in such case, you may need consent for such registration.
Create a USPTO.gov filing account.
Something to keep in mind, if you haven't filed a trademark application to date, you will need an account at the United States Patent and Trademark Office. If you're filing on your own and not through an attorney, you'll need an account to file your trademark application. You set up, you go to the PTO and you set up an online account. It'll verify your identity and set up a system whereby you can make filings.
Foreign applicants are required to have a U.S. licensed attorney of record.
For businesses and individuals located outside of the United States, but wishing to file trademark applications at the United States Patent and Trademark Office, it is a requirement that you have a U.S. licensed attorney. That is, an attorney licensed in one of the states within the United States.
In the application, you want to select the correct filing basis.
As you proceed along with the trademark application, you'll see that one of the issues that comes up is the filing basis for that application. And the United States Patent and Trademark Office gives you various options, and two of them are whether or not you're a use-based application. That means you're claiming that you have used your mark in commerce. The other possibility is that you have a bona fide intent to use your mark in U.S. commerce, and those are two options. There's also options for basing your U.S. application on foreign filed applications and registrations. But the important consideration here is what basis you pick at the time of filing will dictate what you need to include in your application at the time of filing, and it will also dictate what additional documentation and materials you will need to submit later down the road.
Accurate identification of goods and services.
Trademark rights are tied to or associated with particular goods and services. For example, you can have a trademark that exists and is registered for one particular good or service, and then another one is registered but in a totally unrelated field of goods and services. So the identification of your goods and services within your application at the time of filing is very relevant. The goods and services should reflect the actual goods and services that you're providing under the mark. However, how you describe them in the application has some nuances. If you describe them too broadly, then you may run into certain issues. If you describe them too narrowly at the time of filing, well, if it turns out it's not actually accurate, you may have difficulties in then broadening or adding to that, those goods and services later on down the road. And the current system at the United States Patent and Trademark Office offers you a way in which you can use their ID manual to describe your goods and services, and they give you certain descriptions that you can accept. However, sometimes those descriptions don't always accurately describe the goods and services you want to put in your application. So it's always a balancing act to comply with those descriptions in the ID manual to avoid additional costs down the road, because the USPTO will charge you extra fees for not complying with or comporting with their description of goods and services.
Identification of the owner.
Another key issue in an application is ownership. Who are you stating is the owner of that mark set forth in the application? And this may seem straightforward. You'll just say, oh, well, me as an individual. But in actuality, it could be your LLC or your corporation. So if you list one or the other or the converse, then and it truly is not the one you identify, that issue can raise problems down the road when it comes time for the examining attorney to determine whether or not this is a problematic issue for your application.
You enter disclaimers at the time of filing.
An issue to consider at the onset of filing the application is how to treat descriptive wording in your mark. Do you disclaim certain wording up front? A disclaimer is basically a means by where you're saying you're disclaiming a word, you're not claiming any rights to that particular word, but apart from the mark as a whole. So the issue always is do you disclaim it at the onset when you file, or do you wait and see if this issue comes up by the examining attorney and they require a disclaimer? And then there's a whole other issue that where you may be able to prove a certain acquired distinctiveness for a particular descriptive term. So as with many government forms, the United States Patent and Trademark Office's trademark application form seems like just a simple fill in the blank form. But each of those areas within that application raise significant issues to consider prior to filing. So the key takeaway here is that those boxes in that form require significant consideration because filling them out one way or the other may impact your overall trademark rights. It may impact how smoothly your application flows through the prosecution process at the United States Patent and Trademark Office. And ultimately, it could impact how valuable your trademark is in the future. I realize this video has been a very general overview of trademark applications. If I did mention any particular aspect of a trademark application that you would like to have in a future video that gives a deeper dive into that issue, let me know in the comments. And if you are seeking any type of legal assistance in completing your application or having someone file your application, you will find my email in the description below, and you're certainly welcome to reach out to our firm and we can see if we are a good fit to work together. So thanks so much for watching, and check out these next videos because you may find them of help for your business as concerns intellectual property.